Hello. Does your immigration lawyer look at you like a dare who's been caught in headlights when asked about the following immigration solutions that we are about to discuss below? If so, you may need to get a second opinion in one of the most complex areas of law, United States immigration law matters. If you want to learn more about these solutions, stay tuned. Our immigration legal team believes finding legal solutions for our clients is a highly complex and seriously impacts lives when a solution is overlooked. As a result, our law firm has limited our practice to U.S. immigration matters for almost 2 decades. Here I'm going to share a checklist from our law firm that lists some of the legal options you should review if someone you know is out of status or has come into the country uninspected without a visa. Our purpose here is to make you aware and spot issues with your immigration lawyer and attorney. I'll go ahead and point out a few of the legal options on this list for time's sake. Okay, let's get started. First, let's talk about the Nicaraguan Act. You will hear it referred to as NACARA. It is standing for Nicaraguan Adjustment and Central American Relief Act. Okay. It was a relief available in the 1990s to Central and South Americans. If an individual missed the application window, the good news is that the benefit is retroactive, and you may still apply today for NACARA-based permanent resident status if you lived here during that required time period. A child of a successful NACARA applicant, which is number 2, even though the child was not even in the country, the NACARA applicant who was a minor back in the 1990s may be eligible for permanent resident status based on his or her parents' successful application. This is a very powerful form of relief and it shouldn't be missed. The third mention is employment sponsorship. This option allows a U.S. employer who wants to sponsor an undocumented individual to do so in special circumstances. However, a special waiver is required in order to accept the years of unlawful presence in the United States. Employment, of course, is one of the most popular ways next to family sponsorship when an undocumented individual is looking for a path to permanent resident status. Number 4 is derivative citizenship. As you can see on your list. I'm going to jump to number 5, which is the U visa. This is where a crime was committed against a non-resident in the United States. If at any time a crime is committed against an undocumented person residing in the U.S., it is very important to report the crime and cooperate with police authorities. Failure to do so will cause a victim of crime who is undocumented to totally miss out on an avenue to receive permanent resident status with the help of a seasoned immigration lawyer. Don't forget that sexual harassment and abuse is a crime, and being undocumented does not mean you have to endure a crime being committed against you. Number 6 on the list, as you can see, is non-pro-tunc motion. Without getting into what that means, it is a way to forgive falling out of status. Number 7 is family sponsorship. Number 8 is asylum, even if after the 1-year requirement is not met. Number 9 is a T visa. Let's talk about that. A trafficking visa occurs in a variety of ways. If you have been hired as either an au pair, a diplomatic visa helper, or any visa where you are being forced to work way beyond the scope of the specified job without additional pay, or you have been used to perform illegal activities against your will and under threat of duress, a T visa-based green card is a strong possibility and it's not to be overlooked. Marriage to a U.S. fiancé is number 10. Number 11, S visa, if you are a key witness and will cooperate with the legal authorities. Number 12 is a self-petitioning VAWA, if you have been abused, male or female, abandoned or mistreated by a U.S. spouse. Number 13 is ineffective counsel. If an attorney has caused you to be out of status, a remedy is possible. Number 14, a national interest waiver is available if you have a high level of education or you have pursued a cause where you have impacted the United States public interest positively. And if you have been recognized nationally or internationally for your contribution, this is a strong option. Now below there are also the below waivers to forgive criminal unlawful presence, misrepresentation, and so much more, but I only list two. There's the I-601, I-601A waiver for unlawful presence, and number 16, the criminal waivers. Well, I hope that this list can empower anyone who does not know where to begin in resolving his or her out-of-status issues. Schedule an appointment and meet with experienced legal counsel today. Even if your lawyer gives you the deer in headlights look, don't give up and seek another legal opinion elsewhere. All of our lawyers are members of the American Immigration Lawyers Association. We serve clients throughout the entire United States and internationally from our offices based in the Washington, D.C., Maryland, and Virginia area. Thank you for listening. This has been your Scott Bassel Law U.S. Immigration Minutes.